This video is sponsored in part by YouGov.
Mr. Beat presents Supreme Court Briefs.
Chicago, Illinois, 2008. Otis McDonald is increasingly frustrated with the rise of crime in his neighborhood, which is located in the south side of the city. Gangs and drug dealers had been terrorizing him and his neighbors. McDonald, a dude who was up there in age, had lived in his house since 1971. He owned several shotguns, but they weren't enough to help him prevent robbers from invading his home and just taking what they wanted. Because of this, he became determined to purchase a handgun for self-defense. However, there was just one problem. Chicago had generally banned the new registration of handguns since 1982. So McDonald wasn't able to purchase one. That said, he got pretty giddy after he heard about the Supreme Court ruling in DC v. Heller. Now, I have a video about that one, but if you're gonna be all lame and stuff and not watch it, that was the case in which the court clearly said the Second Amendment was about individuals having the right to have weapons to defend themselves. After the Heller decision, McDonald joined forces with 3 other Chicago residents to sue the city in the U.S. District Court for the Northern District of Illinois. However, the U.S. District Court for the Northern District of Illinois was like, sorry bros, and dismissed the lawsuits. After this, McDonald appealed to the Court of Appeals for the 7th Circuit, but it also dismissed the lawsuits, arguing that the decision in DC v. Heller dealt with a federal law. But these lawsuits dealt with local laws, man. Get it straight for real. Yeah, McDonald wasn't having it. He appealed yet again, this time to the Supreme Court, who gladly accepted the case, hearing oral arguments on March 2nd, 2010. During oral arguments, McDonald's lawyers claimed the Chicago law effectively banning handguns was unconstitutional because it was too broad and created too many hoops Chicago residents had to jump through if they wanted any kind of gun. As you might expect, the court definitely considered the DC v. Heller decision, but it still wasn't clear whether or not the Second Amendment applied to states, counties, and cities. McDonald's lawyers actually went as far as arguing that the slaughterhouse cases needed to be overturned. Yeah, I have a video about that case too. Don't be lame now. But if you haven't seen that video, the Supreme Court decided in those cases that the Privileges or Immunities Clause of the 14th Amendment only applied in areas controlled by the federal government and did not apply to the Bill of Rights. McDonald's lawyers thought that the Privileges or Immunities Clause was meant to give the federal government power to enforce the Bill of Rights against states, including, obviously, the Second Amendment. The Second Amendment is part of the Bill of Rights, don't you know? Because of this, both right-leaning and left-leaning activists united to support McDonald in their quest to overturn the slaughterhouse decision. The Due Process Clause of the 14th Amendment, however, could also possibly make the Bill of Rights apply to the states, and so the court had to figure out whether or not the Privileges or Immunities Clause of the 14th Amendment, the Due Process Clause of the 14th Amendment, or both allow the Second Amendment to be applied to the states. Well, on June 28th, 2010, it announced it had sided with McDonald. It was 5-4, with the more right-leaning justices giving the majority opinion. The court said the 14th Amendment definitely makes the Second Amendment's right to have guns for the purpose of self-defense applicable to state and local laws as well. Justice Samuel Alito wrote the majority opinion, saying that the right to self-defense was a, quote, fundamental right that was, quote, deeply rooted in this nation's history and tradition. Now, that said, the court did not overturn the slaughterhouse decision because it ultimately didn't rely on the Privileges or Immunities Clause of the 14th Amendment to decide in this case. It used the Due Process Clause of the 14th Amendment. There were lots of dissenting opinions for this case, but the only one I will focus on is the dissenting opinions by Justices Stephen Breyer, Ruth Bader Ginsburg, and Sonia Sotomayor, who all argued that the Second Amendment does not say that owning a gun is a, quote, fundamental right worth protecting through the 14th Amendment. McDonald v. Chicago opened up a flood of lawsuits, many by the National Rifle Association, against local and state governments across the country. That said, it has not won all those lawsuits, and since the decision, lower courts have upheld that bans on certain guns is still constitutional, as well as additional restrictions on how people can both get and carry guns. Today, around 45% of American households own at least one gun, and the United States, by far, has the highest gun ownership rate in the world. I'll see you for the next Supreme Court case, jury. YouGov is my favorite way to take surveys and make extra cash and earn rewards. I originally started using it when I was stuck in line somewhere, I think the DMV or something, but it's just a great, quick way to answer questions and get rewarded for it. Here I am once again taking a YouGov survey on the toilet. Now that I think of it, it was really inappropriate for me to film this. Anyway, YouGov is free to join and a great way to be heard and earn extra cash. It's a side hustle. It's a life hack. So tap my link in the description to start taking surveys through YouGov and earn cash. Thanks to YouGov for sponsoring this video. If you made it this far in the video, you either skipped ahead unwittingly, or dare I say, you actually like the video. So if you like the video, like the video. And if you shared the video, share the video. And if you subscribe to my channel, subscribe to my channel. Anyway, let me know what Supreme Court case you would like for me to cover next for this series. Let me know by letting me know. If I'm thankful for you watching this video, I'm thankful for you watching this video.